Good day. Today we will talk about the characteristics of law and the sources of law. There are four characteristics of law. The first is that law is a rule of conduct. It simply means that it tells us what should be done and what should not be done, what is legal and what is illegal in our society. It takes cognizance only of external acts, meaning only the external actions or deeds of people are subject under the jurisdiction of the law. You cannot include the realm of the thought. You cannot prosecute a person by the way he thinks, by the way he believes, only his actions if it is not in line or in violation of the law. The second is that law is obligatory in nature. It simply means that we have to obey it. It simply means that we have to observe it. And so, when we violate the law, it imposes a sanction upon us, or it imposes a penalty for each and every one of us. And so, for example, you drive without license, then the authorities can either give you a fine or confiscate your vehicle, and so on and so forth. So the second characteristic of law is obligatory, and all must observe it or all must obey it. The third characteristic of law is that it is promulgated by legitimate authority. And in our jurisdiction, our authority to enact laws falls in the hands of Congress, which is divided into either the Senate or the House of Representatives. Every law that is enacted by Congress takes form in Republic Acts, like Republic Act 7877, 9262, so on and so forth. When law is enacted by the local legislative units like the City Council, it takes the form normally of an ordinance. And number four, we call it is common observance and benefit, meaning we have to obey it in order to benefit from it. So it is intended to regulate, to control the relationship between people in a certain society. And so that when somebody violates the right of another person, then the person that is offended can go to the courts and ask the court for relief or redress of his grievances. And he can ask for damages and so on and so forth. So those are the four characteristics of the law. And we go now with the sources of the law. When we talk about sources of the law, what comes first to mind is the Constitution. It is the highest law of the land. It is the law that allocates the powers of government. As the Constitution divides the power of government into three: the executive department, which applies the law, or the second is the legislative department, which enacts or makes the law, and third is the judiciary, which is the one that interprets the law. And these powers must be exercised fully by those departments, and any law that is enacted by Congress or local legislative in violation of the Constitution will be considered as null and void. The second sources of law is statutes, or what we call as legislations. They are the declared rules by Congress, and in our jurisdiction again, it takes the form of Republic Acts at this point. And they are the main sources of law in our nation. So the second one are local legislations in the form of ordinances. So those are law and statutes. The third sources of law is administrative orders, executive orders, implementing rules and regulations. So AOs, EOs, IRRs are intended to clarify and explain the law and to carry into effect its general provisions. So they are considered valid only when they are not contrary to the Constitution. So for example, you have a particular law, the labor law, for example, and then it comes up with the implementing rule and regulation coming from the Department of Labor and Employment. in order for the DOLE, or the Department of Labor and Employment, to carry out the provisions of the labor code. So that is an example. So when we have the, for example, Republic Acts pertaining to the environment, so the DENR will come up with in implementing rules and regulations, just like uh, the Clean Air Act and other environmental legislations. So from Congress into the specific department of government, the intent manifest, or the manifest intention of Congress there will be made possible. The fourth are judicial decisions, or what we call as jurisprudence. Jurisprudence refers to the decisions of the Supreme Court, and the decision of the Supreme Court is binding upon all the lower courts of the government. And we say that jurisprudence, or the decision of the Supreme Court, forms part of the law of the land. For a particular case where a person's right to security of tenure was violated, he can file a case in the courts. And once it reached the Supreme Court and the Supreme Court renders judgment, the judgment of the Supreme Court, normally indicated in the dispositive portion of the judgment, will be binding upon all the courts. And when there are cases of the same nature, then the judgment of the court in the first case normally also applies to the judgment in the second case. And the purpose of stare decisis, that we call it stare decisis, or the law of precedence, is to have stability in our jurisdiction, in our court's decision. So that's the fourth source of law in our jurisdiction. Of course, the fifth one is customs. So what are customs? They are habits or practices for a long period of time, and they are approved by society as binding rules. For example, in farmlands, in the Kabukiran, when, for example, you have a custom there, you work in a farm, and the owner would tell you that comes harvest time, they will give you 5 sacks of palay. So if you work for 2 hectares, you are expecting 10 sacks of palay during harvest time. So these are the custom of that place, and it is a binding legal rules. So that is an example of custom. But under our law, custom must be proven as a fact according to the rules of evidence. And lastly, what are the other sources of law? You have the principles of justice and equity. You have the canon law, or the law on religion, religious texts and principles. You have legal experts and decisions of foreign courts. For example, in our jurisdiction, we have experts in the Constitution. At times when the courts, or even the Supreme Courts, are in doubt when rendering a decision, they can consult legal experts. For constitutional law, we have the late Father Bernas. So he becomes a friend of the court, or what we call as the amicus curiae. So the court consults him as to the principles involved in the facts of the case, and so on and so forth. So those are the sources of law in our jurisdiction. And again, under Civil Code, Article 3, ignorance of the law excuses no one from compliance therewith. So there is a presumption that a person knows the law by his heart, and that no person can excuse himself for not knowing the law. So in essence, that is our take on the characteristics of the law and the sources of the law in our jurisdiction. Good day to everyone.